Hello and welcome to our program on EEOC Position Statements. On behalf of Aurora Training Advantage, I would like to thank you for joining us. Your guest speaker today is Rebecca Shanlever. Rebecca litigates employment and business disputes and advises clients on a wide variety of employment issues. She has extensive experience handling discrimination, harassment, and retaliation cases through all stages of litigation, from informal settlements and mediations to motion practice and jury trials. She also has significant experience with non-compete and related matters. Questions can be entered in your GoToWebinar control panel, and as many as possible will be answered at the end of the presentation. If anyone didn't get the email this morning with a copy of the slides, you can download these from the handout section in the control panel. Enjoy the program.
Welcome everyone to the good, the bad, and the ugly. I have been working on EEOC position statements for almost my whole career, which is coming up on 20 years. And over that period of time, I've seen some really good ones. I've seen some not so good ones. And I've seen some that were really problematic for my clients down the road. Some of them I've been involved in drafting. Some of them I don't see until there's a lawsuit and my clients hire me to help defend the case. But in all that time, I feel like I've learned, and my clients have learned, a lot of good information, and then sometimes learned the hard way, a lot of good information about position statements, how they should be drafted, what to include, what not to include, and we like to share that information through this webinar. So let's sort of go over a little bit about what we'll talk about during the presentation today. As I mentioned, we'll obviously cover what you should put in a position statement. Almost as important, though, is what to leave out of a position statement. We'll talk about who at the employer, who at the EEOC is part of this process, and talk about the appropriate scope of who needs to know information about the charge itself and how we're going to respond. We'll get into kind of the nitty-gritty details of actually sitting down and drafting a position statement, how to use sections and headings and things like that to write a persuasive position statement. Sort of throughout the presentation, we'll talk about working with legal counsel and the different times during this process that they can and should get involved. We'll, sort of towards the end, we're going to go over 3 different actual position statements from real life, all 3 of which I have been involved with and have been at issue in cases that I've handled. So once we kind of cover these general topics, we'll go through some of these very specific details about actual position statements that were submitted to the EEOC and kind of, with the benefit of hindsight, go back and look at how they could have been done differently, what could have been improved. I'd also like to take questions and hear comments from the folks who are participating today. We'll probably do that towards the end, but feel free to put in a question or a comment as we go during using the chat feature. And as we get towards the end, I'll go back and try to answer those. So you get a charge of discrimination filed by an employee or a former employee. What do you do with it? Where do you start? Obviously, you're going to read the charge, make sure you review everything else that comes with it. Usually what comes from the EEOC is not just the charge itself, but a big packet of information, some document preservation notices, some requests for information sometimes. You're going to want to make sure you review all that information carefully. Then, of course, you're going to notify management as appropriate, maybe your internal legal department if you have one. And probably the first thing that legal is going to do is recommend that you send out what we call a litigation hold notice or a legal hold notice, which is something that goes out to your entire not your entire organization, but to the folks in your organization who may have information related to the charge, so that they know they need to hang on to it. Not that they need to pull it and give it to us necessarily, but that they just need to make sure they don't delete anything. That's just one example, and I did say we'd talk about this throughout the presentation of where legal counsel can be an important benefit throughout the process. You're also probably going to want to notify your insurer if you have one, if you have employment coverage, which many companies do. It's usually referred to as EPLI, Employment Practices Liability Insurance. Most policies will require for there to be any coverage that you give them notice within a certain period of time after finding out about a claim. And certainly a charge in most cases is going to put you on notice of a possible claim, and you need to go ahead and notify the insurer. Their coverage may not kick in until, for example, a lawsuit gets filed, but if you knew that this first step toward a lawsuit had come in and didn't notify the insurer, there is a possibility you could lose coverage. What I almost always do when I get a charge for a client is to ask for an extension from the EEOC. Truth be told, and I don't really put this in the presentation, I usually don't even ask. I just write a letter and say I've received it, I'm representing this company, this employer, and we're going to need some more time to respond. We'll respond by X date. Please let me know if you disagree or if there's any issues with this extension of time. And put the burden back on the EEOC to respond to me. Time is almost always important to make sure you have plenty of opportunity to do everything you need to do to get a good position statement together. And I have found that they almost always either grant a request if you call or don't respond when you send a letter saying that you need additional time. When you're thinking about whether to use legal counsel, and you may want to consider that at the very beginning when you first get a charge and not wait for a lawsuit to happen. Think about a couple things. The EEOC doesn't want you to have an attorney, and they say that you don't have to have one, and you don't from a legal standpoint. Unlike in litigation where a company has to be represented by counsel, at the EEOC proceedings, a company can represent itself without outside legal counsel. Why doesn't EEOC want you to have a lawyer at this stage of the process? Well, the facts that are going to be presented in your position statement, we'll talk about that more when we get to the drafting and address it in some of the example position statements later. But those facts that you're going to include in your position statement, a non-lawyer might waste time and space and maybe even get the facts wrong defending the merits of an employment decision when the employer doesn't really even have to be right. A non-lawyer might not be aware of all the legal defenses that you could present at this stage. Some of them might seem like technicalities, but they're important ones, and you may just not be thinking about them in the way that an attorney would. A non-lawyer might also end up including information that's really beyond what the EEOC is allowed to request because they've gone too far in what they've asked for, and the non-lawyer doesn't necessarily appreciate the narrow scope of what the EEOC is allowed to ask for. Some of those additional defenses are things like timeliness, which again, that may seem like a technicality, but we'll talk about it later how important that defense can be. There's something called a same actor inference, which is just the legal jargon for when the same manager or other decision maker at a company hires an individual and then later makes a negative employment decision about that individual. There's this, not exactly a presumption, that's why we just call it an inference, but there's a strong belief that that person, that manager who hired the person in the first place, couldn't then later discriminate against that person, or at least wouldn't in the normal course of business discriminate against somebody that they brought on in the first place. There are a couple of other legal defenses that are going to jump out to legal counsel that may or may not be so obvious to somebody who is not a lawyer. once you know what these defenses are, that's going to help, that's going to control what information you include or maybe don't include in your position statement to the EEOC. One last place where legal counsel can be really helpful, and you might consider using counsel in this situation even more so than in others, is where the person who's brought the charge is actually still your employee. There is nothing more difficult than managing the day-to-day employment and performance of an employee who has already gone to the EEOC and filed a charge against you. And it's you run the risk of the charging party adding a retaliation claim and expanding the scope of the charge. So legal counsel can help guide an employer through that process. Legal counsel may also help you be able to prepare for an on-site investigation, which can often be the next step after an EEOC charge is filed. That's where the EEOC actually comes to the employer's work site and wants to interview employees and look at documents. Legal counsel can sort of help you navigate those issues and maybe even help you avoid an on-site investigation. Like I mentioned earlier, they'll also have a good understanding of what the EEOC's rights are to request information. A lot of times the EEOC will ask for broad categories of information that goes way beyond what's relevant. Sometimes that's intentional. Sometimes they're trying to cast a wide net and sort of go on a fishing expedition in hopes that they find something. But many times it's not intentional at all. They're using boilerplate requests. These are very busy government employees who have not a lot of time to devote to each and every file on their desk, and they use these boilerplate form requests without any changes to make the request relevant to the particular charges they're dealing with. So again, you can help avoid these situations where the EEOC is overreaching. And then last sort of point here on legal counsel, there are certain kind of hot topics for the EEOC that are usually addressed in their strategic plan that employment lawyers will have seen and be aware of. For example, right now, the EEOC has a couple of areas of big focus. One is blanket termination policies after leave is expired, kind of an automatic termination type policy where an employee is sort of administratively terminated after a certain amount of leave. Those types of blanket leave policies the EEOC is really out there looking for and trying to challenge. Another area is pregnancy discrimination. The EEOC has recently issued some very detailed employment guidance and guidelines on enforcing their rules against pregnancy discrimination. So those are just a couple of examples of hot button issues for the EEOC that a lawyer may be aware of, and having that knowledge that it's an important topic for the EEOC can help guide how you respond and submit your position statement. No matter who is working on the position statement, no matter whether you're getting legal guidance on it or not, what you're going to want to do next is to, once you go through the administrative processes and get your extension, is to sit down and get all the information. It's important to get the facts right at this stage for a couple of reasons. Number one, you just want to know the facts so that you know what happened and you can make appropriate decisions about how to defend the case. And number two, if you don't get the facts right at this stage, then it can be held against the employer down the road. This is part of the reason that we'll talk about this a little more later, that less is often more when you draft a position statement. The shorter it can be, the better. And part of the reason is that that's just fewer facts that are included that you have to verify and be sure about.